all. Today, we are here for the webinar on custodial torture in India, international law obligations and domestic legal framework. Sorry. Our resource person for today is Vaibhav Pratap Singh. Sir has done his BLLB honors from the Faculty of Law, Jamia Millia Islamia in 2017. Have a number of first prizes and best speaker awards starting from debates and MUNs in school up to the moot court competitions during law schools. He is also a founding editor of the Indian Journal of Law and International Affairs, cleared the national exam and interview, and got impaneled as the Judicial Law Clerk cum Research Assistant in the Supreme Court of India. Currently, Sir is practicing before various courts and tribunals across India. We welcome you, sir, and I request you to take over.
Thank you, Ms. Bandi. I thank you, Dr. Nishant Joshi, who's in charge of the Department of Law, PIMR, Ms. Sayali Bandi, who's introduced me, Mr. Nakul Singh Chauhan. Thank you for having me. Today, we are here, as is clear from the title, to talk about custodial torture. And to begin with, I first want to explain what is custody. What do people understand by custody? That definition is not to be found in the Constitution, in the CRPC, in the IPC, in the General Clauses Act. So what does it mean to be in someone's custody? The explanation to this is very nicely given in one line by the United Nations, by the United States Supreme Court in the famous case of Miranda versus Arizona. Now this is a case, as my young law student friends here would know, in the English series and movies we watch, they always read them the Miranda Rights. Whenever someone is arrested, they tell them you have the right to remain silent and anything you say can and will be used against you in a court of law. So this was decided by the US Supreme Court in the case of Miranda versus Arizona, wherein they held that custody means apprehending someone for protective care and to deprive them of their personal liberty. Now, this definition is quite wide. So, for example, children are in the custody of their parents, patients are in the custody of hospitals and doctors. So what we would focus on here is the custody with the criminal justice system. Now, within the criminal justice system, we have custody of two types. One is police custody and the other is judicial custody. In police custody, say you have committed a crime, allegedly, and the police apprehends you. Now, if they want to interrogate you or if they want to do some recovery from you, they will make an arrest. And at that point, you will be in the custody of the police. That is to say, your personal liberty guaranteed to you under the Constitution, at that point has been taken away from you by procedure established by law. And now some of your rights are suspended. You do not have your freedom of movement at that point. You do not have so some of the other rights that stand suspended. Now, the law mandates, this is section 57 of the CRPC, that within 24 hours of being arrested, you must be produced before a magistrate. And the magistrate thereafter must extend your custody either to police or to the judicial custody, or may grant you bail. Now, in police custody, what happens is you remain in a lockup in a police station, what we call the thana. Now, therein the police can interrogate you, they can ask you questions, they can confront you with other witnesses or other persons related to the offense, and they are basically investigating the crime. Now, this custody can extend for the most part only for the first 15 days of your arrest. Thereafter, you can only be sent to judicial custody. Now, judicial custody means you're in the custody of the magistrate, you're in the custody of the court, and therein you're in a prison. Now, by prison, I mean, for example, you have the Tihar jail. Now, the police investigating your case cannot come and interrogate you there without the prior permission of the court. So, custodial torture, given this ambit, would mean torture inflicted upon you by public servants, mainly the police, while you're either in police custody or judicial custody. Now, we focus here not on police brutality that is, say, widespread. Otherwise, for example, recently we experienced the migrant workers and during the lockdowns, how the police beat people up on the roads, people who were simply trying to gather food, etc. While that comes under police brutality, it would not, strictly speaking, be custodial violence. So we restrict ourselves to violence that is done and unleashed onto people, visited upon people under custody, either of the police or the judiciary. Now, the police in India, the police force in India, it must be appreciated. Please tell me if my pace is okay, because I'm just speaking into a camera. I can't see any of you.
No,
So,
so your pace is very good.
pardon?
Sir, we can hear you and it is very audible.
Okay, thank you. So the police force in India work under horrifyingly poor infrastructure. They are extremely overworked. There are glaring vacancies. They are not given proper infrastructure. They have way too much work on their hands. You would be surprised to know that some police stations in rural India have as many as 20, 30 villages under the jurisdiction of one police station. And this police station is not a grand building as we see in cities. This is basically 1.5, 2 rooms. You don't even have proper places where the investigating officer can have a conversation with the accused person or a suspect. And there is no privacy. So there is very poor infrastructure. They work under harsh conditions. They are overworked and they are always at the end of their patience. Now, while none of this is to excuse police torture or police brutality, it is only fair to acknowledge the conditions that have led us where we are. Now, if we want to improve a system, we must first improve the individuals and acknowledge the problems they deal with. Now, this having been said, let's see what has been the history of torture in India. Now, India, by and large, is a peaceful country. We're a peaceful people. We have a celebrated history of non-violence. We got our freedom that way. However, a deeper scratching the surface would show that we have been a violent society, and this is not new. Now I would in fact go back and mention to the readers that the Law Commission of India, in its 273rd report on police torture, brought out that Kautilya's Arthashastra, back in the day, Kautilya's Arthashastra had a whole chapter titled Trial and Torture to Elicit Confession. So they described various ways to torture people to elicit confessions. Now, so this is how far back torture goes in India, systemic torture. Thereafter, we had the 1855 Madras Torture Commission. I'm talking about 1855 Madras Torture Commission. Now, what happened in this case was that India had a tax system by the British. This was the East India Company that was there. So they had these Indian revenue officers to collect tax. Now, the revenue officers, mind you, were Indian citizens who were appointed by the company. So they were given policing powers. So their job would be to collect tax from the Indian farmers. Basically, they were all farmers at that time, by any which way, by hook or by crook. So what they resorted to, I would not go into the details of the deeds they did, but suffice it to say that it led to the formation of a torture commission in 1855. And it is so interesting to note that now these are of course all British gentlemen sitting in the commission, and they noted at the end, they said that it was a regrettable act of a backward and savage people. This is the Indians, because by and large the officers were Indians, though they were working for and on behalf of the British persons. That did not matter. The report concluded that Indians are a backward and savage people, and the commission recommended that India remain under the stringent supervision from their British superiors, and that Indian revenue officers simply were not educated enough or not sophisticated or civilized enough to be able to do their jobs without resorting to violence. So this was the review of officers who had policing powers back in 1855. Now, after that, I would have been so happy today if I could just shake my fists and say, no, they were wrong. We have proved them wrong. Since we have gained independence, we have come a long way. Our police practices are now excellent. No, sadly, there are so many cases of police brutality day in and day out. I can bring out some statistics before you. Now these statistics are that according to the NHRC, that is the National Human Rights Commission, in 2018-19, there were 1,797 deaths in police custody and in judicial custody, and 136 deaths in police custody. That's around 1,800 deaths in a year under the custody of the criminal justice system. This means over 5 deaths a day, and these deaths mean murder. So the law enforcement agencies in India, according to our own National Human Rights Commission, murder 5 people a day. That is a shocking number. It can and should shock the conscience of any person who lives in a civilized society and believes in democracy and the rule of law. Now, we ask ourselves why this is. Why did we start torture back in that day and age, and we continue it till today, especially till today, as recently as the Tamil Nadu case. Now, the reasons that in academia or by our daily practice, for those of us who visit the criminal courts, people say that they have too much pressure. The police officers say that we are buried under too much pressure. We have too many cases to solve. We have a lack of infrastructure, widespread vacancies. There's limited education. This is what the police don't say, but this is some of the reports have said that over 80% of our police force across the country is just the constabulary. That is the constables. So now the educational requirement for constables across the country is it's 10th pass in some places and 12th pass in other places. And now this is not sufficient. This is a person who comes from, by and large, not very well-to-do socioeconomic backgrounds in rural areas and towns. They do not have access to higher education, and then they don't even receive training of that level wherein they are sensitized to a great extent, and they're given that substitute for their lack of education. And now we expect them today to deal with sensitive cases such as gender rights and transgendered persons in custody, cases wherein they have to deal with crimes against women, and they take conservative views. We have so many cases of wherein a female goes to a police station to report a crime against her, a sexual crime against her, and then is in fact raped by the very police person to whom she went for refuge. And now, in fact, one such case, this is, I'm sure as everyone knows, it made huge headlines. This was the Mathura gang rape case. Now, the Mathura gang rape case, this in fact is Tukaram and others versus State of Maharashtra, AIR 1979, Supreme Court, page 185. This case led to us getting section 376 clause 2 subclause B in the IPC, wherein they specifically criminalize rape by the police. Now appreciate this. The Parliament of India, representing 1 billion people, had to come together, sit down and pass a law asking the police and criminalizing their act of raping women. I mean, one would think that goes without saying. One would think you would not have to tell the policeman not to rape women, but it is a horrific reality for which we had a law. However, statistics would not show that after passing of the special law, crimes against women within police stations have gone down by any significant amount. And we would like them to entirely disappear, but that is not a reality. Now, people, by and large, have also supported violence. This is one fact that is so unfortunate. We ask ourselves, we are all educated, for example, we are all people of law in this seminar. However, there are some people of law who support violence. Now, there was, in fact, a chief minister of Madhya Pradesh, I may say, who publicly went on record to say that during her reign, they tortured criminals in police stations and custody till they begged for mercy. Now, this was said with some amount of hubris and with a sense of pomp that, oh, we are so heavy-handed with crimes. Now, this is a chief minister of a state, of Madhya Pradesh, in fact, who said that during her term, criminals were tortured till they begged for mercy. Now, so in India, this is not even the first instance. The said concerned leader enjoys a great mandate with the public. She has followers, and this is not even the first time. I would remind viewers of the Bhagalpur blinding incidents in Bihar, if someone remembers what they were. Now, this is a movie, this is an incident on which the movie Ganga Jal was made. This is the judgment of Khatri versus state of Bihar, wherein what happened was that the Bihar police would apprehend criminals and would blind them by pouring acid and using screwdrivers. Now, what this led to, the shocking part was not that the police did this, which is of course shocking. The shocking part was they received widespread public support. The public was happy. The public believed that they were getting swift justice. त्वरित न्याय कहा गया था उस वक्त इसको. And similarly, we experienced this some 6 months ago in the Hyderabad horrible rape case, wherein the charred body of the victim was found and the accused persons were shot dead in an encounter in a field. There were again widespread support from public. So public, in our experience, has to a great extent supported torture by the police, and this, I strongly believe, adds to their sense of impunity, their sense of, well, their belief that they cannot be taken down because the institution supports them, the public supports them. Who is so it's only a bunch of conscientious judges, lawyers, and activists that are crying hoarse, saying, no, please don't do this. It bothers not the people who are in a position to in fact bring a change. And there are countless such incidents. I mean, there was a National Police Commission report that was commissioned by the government of India, wherein they said that the victims and the complainants in cases force police people to use torture and third-degree methods on accused persons. And if they don't do it, they make false allegations of bribery, etc., against the police. They will simply go to a court, file an application saying that the investigating officer is hand in glove with the accused person if they don't see them being roughed up. Now, in my own experience with the criminal justice system and talking to the police persons, and why, and understanding from them why this happens, they also say that it is a great belief in the minds of many people, including police persons, and I would also say including some lawyers, that people, once they are put in jail, once they are arrested, apprehended, are surely bad people, and they're asking for whatever's coming to them. Now, it is also part of the mindset that you make the process the punishment. Now, when the police apprehend someone, whether or not they will secure a conviction in the future, whether or not the prosecution, the state who will eventually argue the case, will secure a conviction, they will punish the person so much while they can, in their own twisted, contorted idea of justice. This is pure vigilantism. I mean, many police persons off the record have admitted this. I mean, they say, why should we treat them so nicely? Look what he has done. Look what he has done. He's killed children. He's killed other people. He's raped women. So why should we treat them nicely? But I believe that flies directly in the face of our constitution. We are a country governed by the rule of law, where the police is not to assume the role of the judiciary. Police custody, arrest, investigation, none of that is to torture people. None of that is to punish the persons. It's to find facts. It's to find the truth. If you arrest someone and an investigation shows he did not commit a crime, you say that in your charge sheet and the person is set free by a court. Where is the question of torture in this? Now, another great reason, in fact, for torture and why the police do it is that in India, there is an over-reliance on confessions as a method to establish someone's guilt or to bring someone's guilt home. Now, our lawmakers were conscious of this. So when the Indian Evidence Act was drafted, it had sections 24 to 27, which in fact forbade people from using torture or violence to extort confessions. They said confessions made to a police person or while in police custody are not admissible in a court of law. They are irrelevant. So they made that law. They put it on the statute books. However, what happened over time with judicial precedents and practices, that under certain, because they were so sure that confessions would be extracted by violence. If you put enough pressure, if you do enough violence to a person, he will admit things of which he is not guilty. That is simple human nature. It has been shown to us in countless situations. For example, if one were to only study the cases of Guantanamo Bay in the United States and how much information the persons tortured there gave and how much of it was false. Now, our lawmakers were very conscious of this. So they made these provisions wherein they said no confession made to a police officer will be admitted in a court of law or proved against him. However, there are provisions such as 164 of the CRPC, which makes confession given to a magistrate, to a learned magistrate, admissible in a court of law. And through judicial precedents, there are cases of extrajudicial confessions being admissible in a court of law. And there have been judgments that say that in proper cases, conviction can solely be based upon an extrajudicial confession. And sometimes even retracted confessions are relied upon to secure a conviction. They also weigh with the court toward conviction. Now, so what happens is that the police, not wanting to or not being able to properly investigate a case with, say, forensic tools or other instruments, simply want to have a confession in hand. The confession may well be thrown out later, may not be relied upon by the court eventually, may not amount to anything in the court of law, but they like to have it. When they file a charge sheet, it's better not to have anything to show for its investigation in a case rather than a confession. So a deep thinking process over this by learned people is required as to, should we reapproach the reliance on confessions? I mean, the idea not to make confessions central to convictions or prosecution of criminal cases was that the police actually actively investigate cases and finds evidence outside of what the accused himself tells the police. We have a right against self-incrimination. It is Article 20, Clause 3 of the Constitution of India. And there is the landmark case of Nandini Satpathy versus P.L. Dani. Now, Nandini Satpathy was also Chief Minister of a state in whose case this law was laid down. They said we have the accused persons have the right to silence in India. Now, it is not a complete right to silence wherein you can simply not respond to any question by the police. You can only choose not to respond to the questions that incriminate yourself, that tend to incriminate you. However, the police will beat a confession out of you. They will make you admit to things you've never done. You can retract from it later in court. That is your right under law. Now, that much law conscientious judges have developed. However, it hasn't stopped police from doing it anyway. Now, if only someone were to make an assessment or a report of the number of cases in which police had a confession on file and the judge or the court, the judges in the court relied on that confession and ultimately admitted them, it would show a stark picture of how many accused persons allegedly confess before the police, but nothing amounts of those confessions later because they're, of course, just, extorted of them out of violence. Now, this whole conversation that we've had up till now has been very fiercely done with the presumed premise that torture is done upon persons with a view to investigate crimes, with a view to solve crimes. You're putting the bad guys in jail. So what if you cut some corners? What if you bargain some human rights in the process? Ultimately you're putting bad, horrid people away. And some people, sadly, are okay with that. I would bring to your notice cases wherein police do it just for the fun of it. Now, in the recent Tamil Nadu case of Mr. Jayaraj and Mr. Benex, what was the case that the police were solving? What was the confession they were trying to extract? What was the big case they were trying to win? They opened their shop for a few minutes past curfew. That is, allegedly the case is pending. So we should refrain from delving into too many facts and giving our own extrajudicial findings, I would say. However, in this case, it is not about investigative techniques. It is police does these things simply because they can. I would bring to your notice the case of SPS Rathore versus State of Haryana. Now, this is the case of, it made headlines back in the day. This is the case of a young minor girl, Miss Ruchika Girhotra, who was molested by a person no less than the Director General of Police of Haryana. He's the senior most police official in a state. And when proceedings were initiated against him, when the family and their friends made a hue and cry, this police person used all the resources at his behest and tortured the family. One needs only go online and look up the case of Miss Ruchika Girhotra and SPS Rathore and what that family went through for 20 years. The police picked up her younger brother, who was, I think, no older than 10 or 11 years, and kept him in police station without any official records, without recording it anywhere, for weeks, and they tortured him, a child of 10 or 11 years age, to put pressure on Ruchika to withdraw her molestation allegation against the DGP. Now, this is not a case wherein the police is cutting corners to put bad guys away. They're simply using the powers they have to, in fact, blackmail people. So what is to be said about it? So at some point, you must appreciate that it is not only a person bogged down by the weight of his tough job who's just trying to get by and make justice happen. No. There are cases wherein they do just for the fun of it. In fact, I would like to mention here the Stanford prison experiment of 1971. Now, this was an experiment done at Stanford University, wherein they wanted to assess why torture happens. Why is it that when put in prison conditions, people inflict horrible, horrible things on each other? Now, so what they did was they got a bunch of people to agree to an experiment. They paid them some $15 a day. Some people randomly were to be assigned the role of prison guards, and some people were randomly to be assigned the role of prisoners. And they saw that when the experiment started, people started taking their roles very seriously. The guards, and these are all regular, upstanding citizens, they started inflicting violence and torture on the prisoners, and the prisoners started also falling into their role of helplessness. And the study, they gave extensive findings on how it is not so much the personality of a person, but the circumstances of the job and the system that make them inflict and visit this violence upon people. So people must read about this. It's the Stanford prison experiment, and it surely shows you that people torture because they can, because you put them in a position of power over some persons wherein their very life and personal liberties are at their disposal. So they assume that role, and they take it way too seriously. I mean, there have recently been some reports of, that there have been some problems in the findings of the Stanford prison experiment, and how some they were governed by some wrong premises, etc. However, it is still a very interesting read, and we have enough evidence of it in our own country, as the Ruchika Girotra case, wherein police torture you for many reasons, sometimes just for the fun of it, just because they can, including in the Tamil Nadu incident. Now, and it is not just poor, helpless persons they do it to. They've not even spared judges. In fact, people may read the case of Delhi Judicial Services Association versus State of Gujarat. This is a case where the police tied up a sitting judge with ropes, force-fed him alcohol, and took him to the police station and beat him up. So even judges aren't prone or safe. Even the judges aren't safe from custodial violence. This is a case which led to vast furor across the country. The Honorable Supreme Court itself took up the matter and passed strict guidelines for police custody of judges. So no one is immune to this. I mean, you would think it happens to only marginalized people, which it does, by and large. For the most part, it does. But here we have a case of a judge being tortured in custody. So certainly it needs everyone's attention. Not that is the only reason to give it attention, because it also affects judges, but it's simply shocking to me. So now, so we can go on and on and on. And I think the viewers may now by now be convinced that we have enough cases, and these are only the reported cases. Now, I would bring to your attention a very funny aspect of, now this is the National Crime Records Bureau. I came across this during my research for this webinar. This is the NCRB, the National Crime Records Bureau. It is under the Ministry of Home Affairs, and it is the only official source of crime data in India. Now, it reports crimes state-wise and offense-wise. So a funny thing that I found while reading about it is that it follows this principal offense rule. Now, it means that if any offense is covered in a single registered criminal case, and there are two sections that are attached to it, the NCRB will only count the most heinous of the offenses. So, for example, if there is a case that involves murder and rape, they would only report it as a case of rape, and it would add as a case of murder. So it would add to the murder statistic, but not the rape statistic. I don't know. They do this for reasons best known to them. So one can appreciate what the statistics mean and what the real number must be. Now, and we know this, at some level, we know this as a people. We know the problem is endemic to India as a people. In 2016, India's official entry to the Oscars was a movie called Visaranai. Now, this was a movie on police torture and how police torture people to extract confessions. And this was based in Odia jails, I believe. So India's own Oscar submission, as recently as in 2016, was a movie on police brutality and confessions. So we are alive to this problem. Now, what do we do about it? And what have we done about it in the past? Now, we have a string of domestic procedures and domestic substantive laws, such as Section 330 IPC, 331 IPC. This punishes causing hurt to people to extort confessions. So India has said that this is sufficient. This covers police torture because you can't hurt someone to extort a confession. And we have custodial torture law. This we have submitted on international fora. And for the yearly reviews, this is the UPR, I think it's called, where the Attorney General represents the country. We say that we have sufficient laws. However, at the same time, we also agree when they pass resolutions saying India must ratify INCAT, to which I will get to in a few minutes, we say, yes, we must. But then we have not for 20 years now. So we'll get to that in a moment though. Because before that, I want to discuss our own court's role, the role of our own Supreme Court, which I am compelled to say has been phenomenal and outstanding so far. I mean, India's human rights scenario, India's human rights jurisprudence, I think for the most part has the Supreme Court to thank. We start right from the case of, I mentioned Mathura rape case, then after that we had Sunil Batra versus Delhi administration. This is 1983 SCC 488, which in fact saw a visit from the then CJI, Justice H.M. Beg and Justice Krishna Iyer, who themselves for the first time ever visited prisons. Now, this is on 23rd January 1978. They visited prisons in Sunil Batra case themselves, and the CJI himself prepared the memo based on which they passed recommendations later on custody and how people must be treated. Now, after that, we have the case of Kishore Singh versus State of Rajasthan. This is AIR 1981, Supreme Court, page 625, wherein the court held that torture is not only physical, but also mental. So we have forward-looking judgments from the Supreme Court. Then we have the landmark, phenomenal case of Rudal Shah versus State of Bihar, AIR 1983, Supreme Court 1086, wherein the Supreme Court gave compensation to a person who was kept in unlawful custody for 14 years after acquittal by a criminal court. This gentleman was acquitted by a court of law. He was not released for 14 years. He filed a 32 petition in the Supreme Court. Supreme Court held that his confinement was illegal. And then they said that if we don't grant him compensation, this finding is meaningless. It means nothing for me to say your rights have been violated and not redressed. So they gave compensation. Then I think we have one of the most important cases called Sheila Barse versus State of Maharashtra, 1983, volume 2, SCC, page 96, wherein the court gave a slew of directions for female prisoners in prisons and how they are to be treated. The court directed a female judge to make inspections to the court. They said that they are to be informed of the grounds of arrest. The female suspects are to be kept in a separate area where the male suspects are not there. They say that any arrest is to be immediately informed to the nearest legal aid committee by the police. And then after that, we have the case of DK Basu versus State of West Bengal. Now, this also gave requirements to be followed in cases of arrest and detention, and you know how police officers must wear identifiable badges and how they must prepare an arrest memo. And then we have Gauri Shankar and Joginder Kumar, etc. We have a slew of cases, and these are excellent guidelines. And I dare say if we stick to them, there would not be any police torture in India. These guidelines are exhaustive. They have been given after great thoughts by legal luminaries, and this provides sufficient framework to work within. Now, have we followed these guidelines so far? No, we have not. In fact, the Supreme Court has gone on to hold such excellent things. For example, this is a rather relatively recent case of 2009. This is Indu Jain versus State of Madhya Pradesh, AIR 2009, Supreme Court, page 976, wherein the Supreme Court ruled that the death of the detained person due to unhygienic conditions in prison will also be considered a custodial death, and the police officers can be held responsible. Now, the Supreme Court is going to the extent of saying not by active torture, but even by unhygienic conditions, if you die in prison, police are to be held liable. But here we have police who are not held liable for even murdering people in open view. Now, the conviction rate of police persons in cases of custodial violence or custodial death is abysmal, around 5%. That is, imagine if 100 policemen kill 100 people, only 5 of them have been convicted or are convicted. That is absurd. It should really shake us. So, and this is the domestic framework. And now we have also international law obligations. International law is in fact even more fervent. International law, for the most part, in history was considered with the relations of nation states, inter se, of how one country is to deal with another. It didn't so much talk about subjects and persons and individuals. Now, it started developing in this area after the First World War, but it was really after the atrocities that we witnessed in the Second World War, that ultimately led to the formation of the United Nations, that we started developing international humanitarian law. And we had in 1948, after the horrifying scenes of the World War II, the General Assembly saw it fit to include torture against in the Universal Declaration of Human Rights in Article 5, and which said that no one shall be subjected to torture or to cruel, inhuman, or degrading treatment. So that is when it started, and after that, I can name so many of them. There is Article 7 of the International Covenant on Civil and Political Rights, the ICCPR, which is ratified by 153 countries. There is the Convention Against Torture and Other Cruel, Inhuman, or Degrading Treatment or Punishment, which is the UNCAT, which is ratified by 136 countries. It's more now. This seems like an old statistic. Then the Office of the United Nations Human Rights Commissioner says that India has signed 18 human rights conventions, 18 of them, out of which we have ratified 8. Now, to put this in perspective for people who are not very familiar with international law, it is not in the air, because a lot of people believe international law is governed solely by morality. It doesn't amount to anything. It is not enforceable. Now, some of these 8 treaties we've ratified have led to our domestic legislation. For example, the CEDAW. This is the Convention for Elimination of Discrimination Against Women, gave us our Domestic Violence Act. The Convention on Rights of Persons with Disabilities gave us our own Rights of Persons with Disabilities Act 2016. The Conventions on Rights of the Child gave us our Juvenile Justice Act. Now these are model laws created by international bodies and by many countries getting together that have vast ground effect. To say that international law would not be relevant or enough here would completely be a misstatement. So many of our domestic legislations and landmark judgments have been guided by and in fact necessitated by international law conventions. And our own Supreme Court has been a champion of this. When Vishaka versus State of Rajasthan was given back in the day, they interpreted international law conventions and treaties. And because we did not have a domestic law on sexual harassment. So now this brings us to UNCAT, which I mentioned earlier, which is the Convention Against Torture by the United Nations. This is the one that is being talked about by everyone these days, especially after the Tamil Nadu case. Now, the UNCAT is a treaty, it's a convention by the United Nations adopted in 1987 under the age, the aim is to prevent torture and other cruel, inhuman, or degrading treatments. Now, we signed the UNCAT, this is the Convention Against Torture, in 1997. We are today in 2020, we are yet to ratify it. Now, we were one of the signatories, we are yet to ratify it. Now, I would tell you that India is one of the only 5 countries in the world which has not ratified UNCAT. And you want to know who our friends are in this list of 5 persons. It's countries like Sudan, Brunei, and Haiti. This is the company we are sharing in not ratifying UNCAT, which is the Convention Against Torture. Now, is this a proud company? I mean, that is up to people. I mean, if you want to keep this company, sure. But I ask, why should we ratify UNCAT, and will that bring about a huge change? Now, what does UNCAT require? What does it do? Why are we even discussing this convention? The UNCAT requires the states that have ratified it to take action to prevent torture by criminalizing such acts, by enacting domestic legislation. And second, it requires them to not provide exceptional circumstances, not allow exceptional higher orders to allow torture in proper cases. So basically, it wants you not to torture your citizens. Now, is it too much to ask for? Can we as a country, as a people say, no, we don't? I mean, yeah, this sounds okay, but we don't agree to it. No, we do, because torture is one such subject that no country in the world, at least officially, whatever be the ground reality, ever supports. All countries are in unanimity when they say we are against torture and torture must be banned. So does India. For 20 years, India has been telling the international community, yes, we will ratify it. We will bring a law. Sometimes we say we have sufficient law. Other times we support their resolutions. Sometimes we acknowledge them. So it is universally condemned. And at this point, torture is one of those subject matters which has attained the status of customary international law. Now, customary international law is this group of peremptory laws that cannot be violated by anyone. torture is one such thing. What it means is that even say India does not ratify the UNCAT, it can still be enforced on us because it is a law that has assumed such proportions that it is simply not possible or not allowed for any country to violate it, whether or not that country agreed to be bound by it. Now, there are certain exceptions to this, such as you can raise a dispute at the time of ratification, etc., or state practice. However, for torture, I don't believe any country will say, no, we have a long traditional history of torture, so we will preserve it. It's not one of those subject matters. So I would say that it has become jus cogens. Now, jus cogens in state practice, it simply means this, that you can't violate it, whether or not you sign a treaty to that effect, whether or not you ratify such a treaty. So would it make a huge difference if we ratify UNCAT? I mean, it's customary international law anyway, so it can be enforced in India. India can be held accountable in a manner known to international law, even if we don't ratify it. Now, Article 51, Clause C of the Constitution, which is a directive principle of state policy, it says that the state shall endeavor to foster respect for international law and treaty obligations. Now, our respect for international law must be shown by following and implementing international law that we've sort of sworn our allegiance to for 20 years, and we support it everywhere. India stands proudly against torture, but we don't do what it asks us to do. Now there is a question of, can treaties be implemented? Can the domestic courts implement treaties or principles of international law without there being domestic legislation? Now, there is some dispute in this regard between courts. Some say that, no, there is specifically got to be domestic laws passed, domestic acts passed in order to enforce international law on Indian citizens or persons here. And some courts have taken the view that is contrary to this. For example, I would like to quote two such cases which are pertinent and hold the field. This is the case of Gramophone Company versus B.B. Pandey. It's 1984 2 SCC page 534, wherein the court held that the Committee of Nation requires that the rules of international law may be accommodated in the municipal law, even without express legislative sanction. And another case the Supreme Court held, this is the case of Vellore Citizens Welfare Forum versus Union of India and others. This is AIR 1996, Supreme Court page 2715, wherein the court was dealing with the principles of precautionary principle and polluter pays principle. This is tort law, this is environment law. And the court held that in these principles, once they are accepted as part of customary international law, there would be no difficulty in accepting them as part of domestic law. It is almost accepted proposition of law that the rules of customary international law, which are not contrary to the municipal law, shall be deemed to have been incorporated in the domestic law and shall be followed by the courts of law, unquote. So this is our own Supreme Court saying that unless some law needs to be changed or unless it takes away the rights of our people, international treaties or covenants or conventions can be enforced by our courts, even without domestic legislation. So ratifying UNCAT would not by itself wave a magic wand and cure us of our evils. Now, in fact, I would like to mention here, with no sense of levity, I must say that two countries that have ratified the UNCAT are Pakistan and China. It has in fact been many years that the Pakistan and China have ratified UNCAT, and their human rights records, their custodial torture records are anybody's guess. So it is not as if today we will ratify UNCAT and tomorrow all our problems will disappear. It is a systematic change that we need to bring. We need to ratify UNCAT. I say that if I were to give my humble opinion, I would say you ratify UNCAT because it helps us. It will give us technical assistance from Geneva. It will put us in the network of international community working toward one goal. And there's no harm in it. In fact, it sends a wrong message not to do it. There's simply no harm. I mean, I would in fact urge we would also ratify the additional protocol, the optional protocol to UNCAT, which wants to set up a committee and have visits in different countries. Let people come and visit Indian jails. Are we so proper about it that we can't tolerate anybody seeing our jails? And if we can't, then let's change them. Let's make jails. Let's build a system wherein open visitors can come and we don't have to be ashamed about it. Now, this hurts us greatly. Some of, in our famous extradition cases, without naming any names, the persons that are the subject of extradition in foreign courts, they say, no, please don't send me to India because the Indian criminal justice system is barbaric. They will torture me in prison, and then they show statistics. And it is embarrassing at some level for our criminal justice system if people make such allegations and they find some basis in fact. Now these are old statistics of our own governments that they're quoting. It's not anybody's statistic that is out to get us. So let us ratify the UNCAT. Let us take this ground away from them. Let us in fact improve our system. Let us move forward. Now, there is a 2017 prevention of torture bill that is pending before the parliament. Now, it is a good start, and I would say well begun is half done, but the rest half needs to be completed. And it is wanting in some regards. It needs a relook, I'm sure, and I hope and trust those amendments will be made. But it is, for the most part, a good bill. It has been appended with the 273rd report of the Law Commission itself by Justice B.S. Chauhan. He's a great, great judge. I respect him a lot. He's done great things for the country. Now, that bill, hopefully, because we had another bill in 2010 to prevent torture, that bill was passed by the Lok Sabha, was yet to be passed by the Rajya Sabha, but the Lok Sabha was dissolved prior to that. So the bill also lapsed. Let's hope this one does not lapse, and we pass this bill and we ratify the convention. And I would say now many recommendations have been made in these committees. There have been so many committees: the Madhav Menon committee, the committee headed by Mr. Soli Sorabji, and all. Now, I would like to make my own submission in the capacity of a nobody and a mere citizen of this country, wherein I think, as a suggestion to be contemplated by learned people, you make the SPs and the DCPs of the districts personally liable for custodial violence cases. You say that if there is a case of custodial violence, the concerned DCP, the concerned SP will be held liable. I dare say there will not be a case of single custodial violence if it comes down to them. The problem is these cases come to the fore, if at all there is a conviction, which is 5%, it is of these constables, head constables, your sub-inspector. The higher ups are rarely touched in these cases. So you bring in a provision wherein responsibility is fixed on the higher ups. An SP, I tell you, will ensure that no police station in his jurisdiction is doing anything of this sort if responsibility should be fixed on him. Then there are certain other recommendations wherein, and this is also something I was thinking about. Recently, I was watching a webinar of the Delhi High Court, wherein His Honor Mr. Justice Chandrachud, who's a sitting judge of the Supreme Court, was talking about digitization of the country and how the E-Committee of the Supreme Court is digitizing police stations and courts and FSL labs across the country. And this has in fact been done in Telangana. I say digitize them all so that everything has to be done on a computer and nothing can be antedated. Nothing can be predated. For example, what the police does is they will take you in custody, but they will not show you as arrested in any of the papers. So any of the injuries inflicted on you in that moment, they say these are all pre-arrest. The person came like that. So I say digitize everything, install CCTV cameras in all prisons and jail cells. This was in fact ordered by the Supreme Court in 2015. It should be complied with in letter and spirit. I say this has also been recommended by the Law Commission. You amend the Indian Evidence Act and you say that the burden of proof will be on the police to prove that if anybody dies in custody, he did not die of police brutality. You make a presumption. The court should raise a presumption that if anybody dies in custody, it was due to police brutality. Because obviously, what else was it due to? There of course can be cases of prisoners being killed by some other prisoners. That does happen in police, but that is also the duty of the police in whose custody they are to prevent that. So you raise this presumption, again, they will fall in line, they will ensure it does not happen because it will ensure fixing liability. Now, we are not too shy as a country to reverse burdens of proof in criminal law. We do it in TADA, POTA, UAPA. We are as a country okay with passing laws that puts strict burdens of proof and presumptions on people. Let's turn it on its head and put it on the police that if there is a case of torture, we will presume you did it. Now, it is a rebuttable presumption. You explain, you convince the court that you did not do it. I believe that would go a long way in preventing torture. Then I say the compensation that is given. Now that compensation, where does it come out of? It comes out of the exchequer of the state. It comes out, that is my money and your money. It is our taxpayer rupees that are paid to them. Now, obviously, people should be compensated, victims should be compensated. There are schemes to this effect, excellent schemes also, I would say. However, that money should be recovered from the erring officials. You recover the compensation paid to the victims, make it high, and recover it from the policemen or any public officials who are responsible for the torture. Again, it would hurt their pockets where it matters, and it would strongly bring down custodial torture. Now, also, I believe we should decrease the reliance on confessions. Police should be armed. The Prakash Singh guidelines, this is the case of 2006, Prakash Singh versus Union of India. With the citation, this is Prakash Singh versus Union of India, 2006, volume 8, SCC, page 1, wherein the Supreme Court gave a slew of guidelines on police reform. They say that every state should make a police complaints authority. They should make a state security commission. Your law and order police should be separate from your investigations police so that they're not overworked. Investigation should be technology savvy, and that, you know, the police should be trained better so that they don't have to rely on confessions to bring guilt home. So these are some of the recommendations that I think we should undertake. So insofar as ratifying or not ratifying UNCAT is, do it. But I think we have, if we only enforce Sheila Barse, we enforce DK Basu and sufficient guidelines, we don't need any of these conventions. They don't bring anything new that is alien to our jurisprudence. We have enough guidelines, we have enough laws, we have enough rules. We should enforce them well. So yes, I mean, that is what I would say. Now, if any of you have any questions, I'll be happy to take them.
I request all the participants, if anyone has any question, please raise your hand so that we can unmute you.
Ma'am, in the meanwhile, you can raise the question asked by Shubham in the chat.
Okay, Nakul sir.
Can you please read it out for me?
Yes, sir. Shubham Singh Kera, he has a question for you. He says that we generally see that police की मार से अच्छे बोल पड़ते हैं. Now, sir, I am not saying that police beating is good or even partially good, but sometimes it does bring the truth out in front, and I think that it is a fact. What do you think? Is it even debatable? It would be an honor to hear you for saying something on this.
See, first, at the outset, I would say everything is debatable. It's a free country with a vibrant people who are learned in their ways. I think we should debate everything and then convince ourselves. Now, you say that sometimes torture brings out the truth from people and it leads to solving of the crime. Now, you know, a very crude form of this is given in a situation wherein you say, if, for example, if there is a ticking time bomb and there is a person in custody who can tell you where it is and how it is to be diffused, will you torture that person? This is the crudest form of this question. And in fact, if Mr. Shubham Singh Kirar would unmute and answer this question for me, there is a ticking time bomb and you have a person in custody who can tell you where it is and how to defuse it. Would you torture that person to prevent a time bomb from going off and killing, say, 1,000 people?
Shubham, I have allowed you to speak. You can unmute yourself to interact with sir directly.
Okay, sir. Thank you. No, sir. About that question, no, sir. It is not a good idea to beat that person who can tell you how to defuse the
even
bomb.
though it would save thousands of lives.
Yeah, sir. But there is a matter of thousands of lives. So that is why we cannot beat that person. If he doesn't tell you how to defuse that, then either way, the people are going to die.
See, very well. I believe so. You answered your own question. Now, this.
Yes, sir.
Now, some people do answer yes to this question. They say, yes, why not? Let's torture the person and let's get information out of him. Experience has shown that once you allow torture in some exceptional circumstances, it is a very slippery slope. It takes you down a horrid path wherein the police then starts taking liberty, and this is with the premise that some people and we as a people are okay with torture to extract credible information. Number one, credible information is unlikely to come when you torture people. They will tell you lies to make you stop. They will admit to anything you want them to say. Number two, it is a horrible slippery slope that we don't want to go down because it is impossible to then control, and experience has shown this in our history. So torture, this is why when I talked earlier of there is some disturbance in the line. Shiva, may I request you to mute yourself again? Yeah, so in fact, when I earlier talked of customary international law, the international customary law on torture says that there are no exceptions to it. That is what the UNCAT says, that you can authorize absolutely no extreme circumstances where you say ki in this situation torture is fine. So I say it is a non-starter. You evolve your intelligence, you evolve your investigative methods. Investigation is difficult, I understand, and the state has the obligation to keep its people safe. But torture is not the way to do it.
Thank you so much, sir. Thank you for answering my question.
So we have one more question from Forum Mehta. I would request Forum to please unmute yourself and ask your question. Forum?
Yeah, Forum, you can now unmute yourself.
Yes, sir. So my question is, sir, can you hear me?
Yes, please.
My question is, since nowadays mental health is like buzzing a lot, and of course the policemen are also a very important part of the society. Do you, in your opinion, do you recommend strict counseling of policemen, especially the prisoners and those who hold like good power?
Absolutely. I would say good mental health will benefit everybody in every field, not just police brutality or law enforcement. In fact, I believe some directions to this effect were also given by the Honorable Madras High Court in the recent Tamil Nadu case, wherein the state already had a program for police wellness and well-being, wherein they're given counseling. So I believe it will go to a great extent, because it will be unfair to the police if we don't acknowledge why this happens. We say, let's punish them, let's make it stop. But that approach so far has not been effective. So I believe now we should also take the route of bettering or trying to better their mental health, and perhaps that would reduce torture. It should definitely bring it down to some level at least, and the state has recognized. Some states do have this program. They have police sensitization programs and mental well-being programs, and I believe they should be promoted even more. They should be sufficiently funded. So I would agree with your suggestion. It is a good move.
Thank you, sir.
So we have one more question from Dhananjay Mahadure. Dhananjay.
Dhananjay, you can unmute yourself now to ask the question.
Thank you, sir. Sir, my question is, according to you, what should be the punishment or remedies of custodial that?
Dhananjay, by remedies, I understand you may be asking about the ways forward. So there are certain suggestions I gave at the end about digitization and making higher officers liable, CCTVs, burdens of proof, compensation, decreasing reliance on confession. Now, if you're asking about punishment, and if by that do you mean sentencing, then what should be the sentence given to them if held guilty?
Yes, sir. Yes, sir.
Okay, so in this, I would say they should be on the same principle. For example, the torture bill, I believe it puts it somewhere around 3 to 10 years, depending on what the injury inflicted is and what the effect they've had is. However, it has some problems because they only acknowledge hurt and grievous hurt. There are some aspects lacking about, for example, water torture or torture by not letting you sleep, or torture of other kinds, which will not come within grievous hurt within the meaning of our IPC. So far as the acts of torture, which are covered by acts that are also covered by IPC, I believe the same sentences should be there, perhaps a little higher, but this needs actual deliberation by a committee that is expert in this behalf in penology. I mean, for example, I would bring before you the example of the seatbelt law. The punishment for not wearing a seatbelt is a fine of not a lot of money, but it is one of the most followed laws of the country. Now, you can make the punishment for everything death penalty if you think having a very high penalty would bring it down, but experience has shown it does not work. What works is the guarantee of conviction. You should know that you will not be able to escape the system, be howsoever high or low the punishment. So the punishment should be imprisonment, of course. Now, of how many years, that will depend. It needs to be deliberated. I mean, I can say a number of years, but it wouldn't be scientific. There's a great deal of research and principles that go behind determining the years of jail time that goes in these places. But I would say if that is what you were leaning toward, you should make it stringent in 20 years, 30 years, death penalty. That may not do much if it's not properly enforced. Even a punishment of 3 years can do wonders if there is some sort of guarantee that you will receive that punishment by the end of it.
Okay, sir. Thank you, sir.
I request all the participants that if you have any other doubts, you can raise your hand and we can make you interact with sir directly. Okay, we have a hand raise from Anshika Singh. Anshika, I have allowed you to talk. You'll have to unmute yourself now.
Yes, sir. Good afternoon, sir. Sir, my question is, sir, I have it's a more of a suggestion that if we hear so many cases about custodial torture and everything, and we see on ground level that inquiries go on happening in these cases. And I guess there are very less, as we see in statistics, there is a very less number of conclusion which is drawn from them. So why can't we have a separate tribunal or a different court, such as we have courts for labor courts, etc., and family courts for different matters? So why can't we have a court for police officers for this particular matter, custodial torture?
Thank you for your question, Anshika. I like your thinking on this. I like how your mind is working. And we have in our country resulted a great deal on tribunalization and making special courts and fast track courts for many things. But over time, they all are prone to similar vices. For example, of staffing, of infrastructure, and the 2017 torture bill that is currently pending before the parliament, it puts a timeline. It says that cases of custodial violence must be decided within a year. So it does provide a timeline. However, this timeline exists, I may tell you, for many cases, for example, check bounce cases and other cases also, but it becomes very difficult practically to enforce them. And so far as custodial violence cases go, the Prakash Singh judgment of 2006 that I mentioned earlier, it directed the establishment of police complaints authorities in every state. So MP also has it, Delhi also has it, most states have it now, though they've not implemented it in letter and spirit. But these authorities, mostly headed by retired high court judges, they are dedicated authorities to look into police brutality and cases of custodial violence. And their recommendations for criminal action, etc., are binding on the government, or at least they're supposed to be. They are not in all the states, but Supreme Court meant that they would be binding. So we do have a dedicated authority for this. Now, a court of law, we can look into that, but I believe your regular criminal courts are very well equipped to handle them. It's just that what you must appreciate is that the police sort of is in charge of bringing a case to prosecution. Courts only enter the picture once they file a charge sheet. They don't file charge sheets. The police is in charge of investigation. They will never file a charge sheet. The court, in its wisdom, and because judges are conscientious, they will bring it to its logical conclusion soon. Judges work very hard. So do the policemen. But in custodial violence cases, we've seen police don't fight charge sheet against their own brothers. There's a brotherhood that goes with it. So
Exactly, sir.
courts may not do as much as we think they would.
Okay, sir. Thank you, sir.
Sir, we have another hand raise from Jigna. Jigna, you'll have to unmute yourself now.
Yeah, sir. Good afternoon. I have a question. The prisoners have a specific time period given to meet their family members. But practically what happens is when the family members, there are many prisoners in one area. So when the family members practically go to meet them, usually they are passed out with the lines. They just raise their hands and show that they are alive. And this is the situation what I'm going through. And thus they have to leave because the other one is next in waiting. So do you think the system should be changed, or the time should be increased, or there should be some modification in this which may help prisoners to have a word with their family members and maybe interact with them in a better way?
Ms. Mehta, you sound like you've had some experience with prisons. You
No. Sir, basically I go to NGOs and I get people there, some experiences of their own.
Yes, because it sounded like a concern of a person who's seen this injustice happen
Yes, sir.
to others. So I would agree with you. As a lawyer also, visiting a prison is quite painful. The atmosphere is simply, it's quite difficult to be there, and this does happen. Now, you must appreciate that we are a country of great restraints financially and infrastructurally. We have our constraints, and they work within those, and definitely something needs to be done. These are rights that are not a favor. You don't do a prisoner or a convict a favor by letting them meet their family. It is a right guaranteed to them by statutes and prison manuals and the Constitution. In fact, this is also something that would go a great deal in reducing torture. If you give people open access to lawyers and family members in visitations, then these instances of torture can be highlighted at the right time. In fact, this was a direction given in Sheila Barsing's case, wherein they said, you let the people meet prisoners, you let visitors meet prisoners, you let visitors, non-official visitors, make surprise visits to prisons and give them open access to the prisoners. So in fact, this suggestion can go a long way in curbing torture.
Thank you so much. Totally agree. Yeah, thank you so much.
If there are any other participants who want to ask anything, any query, any doubt from sir, you may raise your hand. Okay, Sarvangi has raised her hand, sir. Sarvangi, you'll have to unmute yourself now.
Yes, sir. Can you hear me?
Yeah, you're audible.
So I want to ask this. We are talking about custodial torture. So what about terrorism and terrorists? And they are also the part of the same custody. And if we become so lenient about them, so I don't think so we can get any lead or anything what they are planning about. I wanted to ask about your point of view on that.
May I ask you to elaborate on what you mean by lenient? What is getting lenient with?
I mean, sir, there are so many. We can take a example of Pakistan or their terrorism attack continuously. They are attacking on the border. So if we get any terrorist or handed over here, so if we become so lenient in the custody, how can we get any lead if what they're planning about against a country or anything there?
No. Again, I would ask you to try to elaborate what you mean by being lenient.
Sir, I mean the action taken against by the policeman or military person. Lenient means what? How can I put this? So normally asking question or taking confession from them.
There are no legal foundations on normally asking questions or taking confessions by the police. It is only illegal to violate their human rights. There are no fetters on the police or armed personnel in extracting any confession. And in fact, the legal basis of confessions in this country, our jurisprudence, is squarely based on the confessions being voluntary. So in fact, I would tell you that as per our own law, this is section 24 of the Evidence Act, the moment a confession is one that is actuated by torture or custodial violence, it becomes inadmissible. So you may very well extract a confession, but our own law makes it inadmissible. So torture is not an acceptable way of interrogation. And I would simply say that not violating their human rights would not be considered being lenient with them.
Okay, sir. Thank you.
Last and final call for any questions that you might have, or if you want to have any interaction with sir, you can raise your hand. Okay, we have another once again a hand raise from forum. Forum, you'll have to unmute yourself now.
Yeah. Good afternoon once again, sir. So my question is, there are a lot of countries, excluding India, of course, who actually survey on criminals who have done heinous crimes. For example, I would like to give the Ted Bundy. A lot of people have read about him. So there are a lot of series and even documentaries made on him and whatever confessions he had made. So do you think any such kind of a survey or the idea of something such would prove to be helpful for our country?
Surveys are definitely helpful. See, I personally am a huge believer and supporter of giving a greater role to the civil society in public administration, especially criminal justice system, because the system is so overwhelmed that they lack resources and the encouragement to take out surveys such as this one. So when civil society such as NGOs and Good Samaritans do such surveys, they bring forth great data, I mean, revealing data, I would say, and it puts a lot of people to work. For example, when the Supreme Court gave its Prakash Singh guidelines, there were many reports and many surveys whose results were before it, and that is why it could take an informed decision. So we should definitely have more such surveys and programs wherein people go to prison. In fact, again, I would go back to that case. Because it is actually singularly so important of Sheila Barse. How that case came to be in the Supreme Court was because Miss Sheila Barse, who was a journalist, went to police stations and prisons in Bombay to interview prisoners. She went actually to do a survey of sorts, as you say. And that is when the conditions that prevailed there came to the notice of the court and great change was brought about. So yes, definitely, big supporter of what you suggested.
Okay, thank you, sir.
So I think there are no further doubts or queries. Sayali ma'am, please proceed.
In fact, Ms. Sally, if there are any, I can give you my email ID later, which you can share with the people. So if there are, I would perhaps be able to respond to a few of them if they have some of the concerns.
Sir, you can write down your email ID in the chat box, so all the attendees will be able to see it.
Very well.
And I believe Sayali ma'am also has a question from you.
Yes, even I have a question. My question is regarding when we know about the 5 theories of punishment. One of those theories is deterrent theory, and in a society like us, this theory really has a great effect. If deterrent theory is not that implemented, will the society not face crime like we are facing right now? Because I think deterrent theory is needed, is much needed. And maybe custodial torture is one of the reasons of deterrent theory, but deterrent theory is really needed. How can we make a balance between deterrent theory and custodial torture?
I would not be quick in dismissing or writing off deterrence as a theory at all. You know, most civilized nations have moved from deterrence to reformation. However, I would say deterrence still holds a lot of water, especially in a society like ours. But that deterrence comes not from the quantum of punishment. It comes not from the severity of the punishment inflicted. It comes from certainty of conviction. Again, I would say. So you don't need to inflict custodial torture on someone. You don't need to make the punishment for every offense 50 years or 60 years of death penalty. No, you simply ensure that your system works. There are few breakdowns. There is less corruption, and you ensure that justice will be done and people will be punished. And that is what deters criminals. I will tell you, the punishment for some heinous crimes is very high these days. It is, for example, under the POCSO, it is also the death penalty for rape. Have rape on minors since we enacted POCSO? They do not. They have not. So our history and our, in fact, surveys and research on deterrence has shown that making punishments severe, making people suffer at that level is not what deterrence, what brings about deterrence. It is the surety that they will be brought to book, they will be brought to justice, which will give deterrence to people.
Thank you. So we are very thankful that you gave us this opportunity of conducting the webinar. The IMR Department of Law will always be very thankful, and we are further looking to have many more webinars of yours with for the welfare of students and teachers.
I'm honored to be here, and thank you for having me.
Thank you. Thank you, Nakul sir.
Sir, I would also like to add something. There's this old adage that with age comes wisdom, but I think you proved that adage wrong, because this was one of the most well-researched webinars that I've attended, and I could see you scrolling through the pages, the way you explained things, and I personally belong to, the way you scroll things, and the way you explain things, because I don't belong to law background. I'm a management faculty. But for me also it was interesting. You went all the way back to Kautilya's Arthashastra, and then you came to the most recent judgments on custodial torture. So it was a great learning experience for me also. And we thank you for being here with us. It's really sad that our department in charge could not be here with us today because of some urgent engagement. But the moment we proposed to him that we want to have you, and the moment he looked at your profile, he was more excited than us for you to come and interact with our students. So thank you so much for being here with us.
My pleasure entirely.
Thank you, sir.
So with this, I'm ending the webinar. Thank you everyone for joining us here today.
Thank you.
Okay, there's a final hand raise. I think we should. Devansh wants to say something. Devansh, you'll have to unmute yourself.
Sir, can we get the email ID?
Sorry?
Sir, can we get sir's email ID? Sir, I had not
It's available on the chat box, Devansh. Yeah.
Okay.
Or you can just drop me a personal message. I've noted it. I'll forward it to you.
Thank you, sir.
Okay.
Sir, I will drop it.
Yeah. So thank you everyone for being here with us today.
There's another message that says that they've not received it. I believe you can address it.
Jigna, you'll have to read sir's message in the chat above, and it's available to all the panelists. So I think Jigna is an external participant. She's not from our institute.
I'm typing it again for everyone's benefit.
I'll just read out sir's ID again. It's ADV, short for advocate, adv.vaibhavpsingh@gmail.com. That's the ID. Yeah, and sir has also sent the ID again. Sir, Jigna has seen your ID. So thank you everyone for being here. And sir, we look forward to further enhance our knowledge from your end. Thank you, sir. Thank you.
Thank you, sir.